Every day, roughly 400,000 people cross the Canada-US border. For most, this is annoying, maybe stressful, but ultimately an uneventful process. However, for a small number, the events that follow a border crossing will change their lives forever. You don't want to be in that number. My name is George Gray. I'm a criminal defense lawyer based in Toronto. On this channel, I explore topics in criminal law that matter to all Canadians and that all Canadians should understand. Today, we're going to talk about the border. First, we're going to talk about drugs at the border. How much trouble would you be in if you were caught with drugs in your suitcase? And how likely are you to get caught? Then we're going to talk about the powers of border guards and what rights you have at the border. Finally, we're going to focus on phones and laptops. Can border guards search your phone? And if they can, are you required to provide your password to them? The answers are going to surprise you, especially if you live in Ontario or Alberta. So before you plan your next trip abroad, watch this video to learn the basics that can help you stay out of legal trouble. And as always, none of what I'm going to talk about today is legal advice. This video is for entertainment and educational purposes. If you're in need of legal advice, you should speak with a lawyer. If you wish, you can reach out to my firm directly via the contact information below. So let's talk about drugs at the border. Drugs are by a wide margin the most frequently found contraband at the border. The basics are that if you are caught crossing into or from Canada with illegal drugs, you will very likely be charged with the offense of importing or exporting a controlled substance. This is a very serious offense, straight indictable with a max sentence of life in prison for Schedule I drugs like cocaine, MDMA, and most opiates. Marijuana remains illegal to cross the border with, and if you were caught crossing the border with marijuana, you would be charged under the Cannabis Act. It's still a serious offense for which the Crown would likely seek a jail sentence. So, does it matter how much drugs? Yes, it does matter a lot. Now, there is no minimum threshold, so technically, even trace amounts of a drug like cocaine could bring the same charges as bringing 20 kilos across the border. And the Crown does not have to prove that you intended to sell the drugs once you got across the border. But they do need to prove that you intentionally brought drugs across the border. So if it's a small amount, the Crown may not be able to convince a judge or a jury that this wasn't just an accident. Now, let's talk about how much trouble crossing the border with drugs could get you in. And I'm going to focus on cocaine. In Canada, you could assault your wife, you could drive at twice the legal limit of alcohol in your blood, or you could deal dangerous drugs to addicts on the street. You can do any of these things and you will stand an excellent chance of staying out of jail. But if you cross the border with a substantial amount of cocaine, the starting point for sentencing is 6 years in the pen. There are very few other offenses in Canada that will get a first offender a sentence that long. Now, obviously, there are many reasons why drug smuggling is wrong and needs to be punished. The national security interests of Canada in policing and securing its border are, of course, important. But the other crimes that I mentioned are serious too. And is it really clear that the moral culpability associated with crossing a border with drugs is that much worse than, say, inflicting violence on someone? And the sad truth is that most people caught smuggling drugs are young women with no criminal records, many of whom have been manipulated into taking drugs across the border. And the real bad guys who are pulling the puppet strings and making real money are rarely caught. So my PSA is this. Please understand that if you are caught carrying drugs across the border, the law will deal with you very severely, more severely than it would with the vast majority of other crimes. But people don't smuggle drugs because they think they will get a light sentence. People smuggle drugs because they think they won't get caught. But people underestimate the sophistication of the tools that are available to border guards. And it starts before you even get to the airport. So if you are booked on a flight into or out of Canada, the CBSA, the Canada Border Services Agency, will have already looked at your profile to assess the risk that you are carrying contraband. Now, their exact methods are confidential, but they're certainly going to be looking for things like your travel patterns, and especially whether you are traveling alone. They're going to look at when you bought your ticket, and they'll be looking in particular for last minute ticket purchases. They will look at how you paid for your ticket and how the cost of the ticket lines up with what they know about your financial means. Now, you should know the CBSA shares information with other government ministries, so they may know more about you than you might expect. And of course, they're going to be looking at where you come from, with more concern about airports that service South America, Houston or Miami, and of course, direct flights from South America and the Caribbean. No single factor is going to get you flagged, but taken together, the CBSA's algorithm may deem you to be suspicious. When that happens, a lookout will be issued, meaning that they've already decided to pull you aside for secondary screening, often before you even step foot in the airport. If this process seems opaque, just wait until 2027. That is when the CBSA plans to fully implement a new AI-generated border tool. Not unlike the 2002 film Minority Report, this tool, called the Traveler Compliance Indicator, is going to assign a score to every traveler that predicts whether they're going to be behaving badly or not. Welcome to the dystopian future where we're policed by artificial intelligence. When you first arrive at customs, everyone goes through primary screening. But if you're flagged by a lookout or seem suspicious during primary screening, or perhaps are just chosen at random, then you're sent to secondary. There, you can be confident that border guards will very likely find anything you're trying to hide. They will question you in much greater detail, but they can also search and x-ray and run tests on your luggage. For example, they can run what's called a NIC test on your suitcase or your clothing or even your credit card. This test will show positive if your belongings have ever been in contact or even close to a narcotic. If there is a positive NIC test, that is not grounds for being charged, but border agents are then likely going to begin what they call destructive inspections. That means they're going to empty your suitcase and start cutting into it or dismantling it. And they are very likely going to find anything you might have hidden there. And here's where you might say to me, as a Canadian, don't I have the right under the Charter to be free of a search this intrusive without a warrant? And that brings me to my next point. I often hear from clients who are surprised to learn that their rights under the Charter do not apply, at least to the same extent when they're crossing a border. The Supreme Court of Canada, in a 1988 decision called Simons, wrote, "The degree of personal privacy reasonably expected at customs is lower than in most other situations. People do not expect to be able to cross international borders free from scrutiny. It is commonly accepted that sovereign states have the right to control both who and what enters their boundaries." Fair enough. But what are the practical implications of this? Well, for one, the protections of Section 8 of the Charter, the right to be free of unreasonable search and seizure, are deeply diluted. CBSA agents are able to search you and your luggage without a warrant, up to and including strip searches and body cavity searches. And what other Charter rights are dialed back? Well, what about the right to silence under Section 7 of the Charter? At the border, you are required by law to answer questions about what you're bringing into the country and to do so honestly. What else? Well, you're not allowed to just leave. Once you're in customs, there's no turning back. In a very real sense, you are being detained there until they say you can go. So does that mean that you have the right to a lawyer like you normally would upon being detained? Well, it gets complicated. What constitutes a detention, legally speaking, is different at the border than it is elsewhere. And routine questions and searches do not constitute a detention. But what you need to understand is that these rights are only diluted up to a certain point. If and when the questions posed to you go beyond routine questioning and searches, and you become subject of what is called particularized suspicion, at that point your charter rights are back and you need to speak with a lawyer ASAP. This brings me to my fourth point. For good reason, few travelers understand if and when border agents are allowed to look through their cell phones or laptops. Hold on, because this gets a little complicated. The CBSA has always taken the position that electronic devices are like any other good brought across the border, and thus they are able to, and in fact required by the Customs Act, to inspect them, like they would with a suitcase. And up until fairly recently, courts had ruled that the CBSA was right. Without any objective evidence of wrongdoing required, CBSA officers were allowed to search travelers' phones, and that they did. Border agents in Canada have searched tens of thousands of phones and other devices over the past number of years. However, in 2020, the Alberta Court of Appeal found that groundless searches of electronic devices at the border were unconstitutional. And in 2024, the Ontario Court of Appeal decided the same thing. The Ontario Court of Appeal said that the search of a cell phone is so fundamentally more intrusive compared to the search of a suitcase that there needs to be something more than a hunch by border guards to justify a search. Both appellate courts gave Parliament time to amend the Customs Act before their ruling striking down portions of that act were given effect. But the time for that has now passed and Parliament didn't change anything. As a result, the portions of the Customs Act allowing groundless searches of digital devices is officially of no force and effect in Ontario and Alberta. This has resulted in a rather bizarre situation. The CBSA has issued internal bulletins instructing its officers that they must have reasonable grounds to suspect an offense before searching a digital device. But their statutory basis for searching phones at all in Alberta and Ontario no longer exists. So where does that leave us? In Ontario and Alberta, CBSA officers are relying on internal policy and on common law search powers rather than on a statutory authority. and it's highly debatable if they have the power to search phones in these provinces at all. Now, this video has been filmed in March 2026. The situation can change at any time, so this may no longer be accurate depending on when you're watching this. What is clear though is that at the border, searches of a phone are no longer seen as being on the same level as a search of a suitcase. Officers must have some kind of basis for believing that a traveler is involved in a crime in order to search their digital devices. As we discussed earlier, the existence of such a particularized suspicion has implications for your rights. If an officer is seeking to search your phone, there is a good argument that you would be considered detained and therefore must be told without delay that you have the right to a lawyer. And you can even ask a border officer, if my phone is being searched based on a reasonable suspicion, am I now under detention and do I have the right to a lawyer? If you're not told you have the right to a lawyer, this could have implications down the road at a potential trial. But the law now is so uncertain at this point in time that charges relating to a scenario like this would be extremely vulnerable to a charter challenge at trial, especially in Ontario and Alberta. Now, setting aside whether border agents are entitled to search your devices, if they wish to do so, do you have to provide your password? The first thing to note is that it is an offense under the Customs Act to resist or refuse to comply with a lawful border search. This is the offense of hindering. However, as we've been discussing, it is not exactly clear at this point when a border search of a phone is lawful, and the current CBSA policy is to confiscate devices and not charge for hindering just for refusing to provide a device password. And remember that the provisions of the Customs Act that are interpreted as requiring travelers to provide their device password have been read down now in Ontario and Alberta. So if you refuse to provide a password in one of those provinces, the CBSA cannot point to a valid constitutional statute that compels you to do so. However, the CBSA still can and likely will seize your device for further examination. This doesn't require your password. They just send your phone to a forensic lab to be cracked, a process that usually takes months. Also, if you are not a Canadian citizen, a refusal to provide a device password could be used as a basis to deny you entry into Canada entirely. Crossing the border is routine for most Canadians, but knowing what can happen and what your rights are can make the difference between a smooth re-entry and a legal nightmare. If you are dealing with a legal situation involving a border crossing or any criminal issue, feel free to reach out to my office directly via the contact information in the description below. For everyone else, if you found this video interesting, please like and subscribe for more deep dives on how criminal law works in real life. Thanks for watching.